Here we are at the Law Professor channel, where we disseminate information about legal education. And today's series is a continuation of examination tips. We were looking at some examination questions and getting a framework on how to answer them. And today we'll focus on the subject of legal methods. We have here with us Dr. Karibi-Whyte, who has decades of experience in teaching this subject, and she'll be taking us through the structure of this examination and the expectations of your examiners. Dr. Karibi-Whyte, you are welcome to the Law Professor channel.
Thank you. Good day, everyone. I'll be taking some questions and I'll be explaining what the examiner really wants, not everything. Because most times in legal theory, which is a mini jurisprudence, students attack the questions and write everything they know about a particular thematic theme. No. The general rule for legal method or for jurisprudence is that we ask you that so and so have said this. Like we say, HLA Act has said this. What are you saying? That's the general rule. When we ask such questions, what we're saying is that you first tell us what HLA Act has said. You now tell us what you think. Even in analyzing what HLA has said, places where you agree with him, you tell us. Where you disagree with him, you tell us. That is what the examiner is looking for. Not just rehashing what HLA has said and then you end it. No, you must say what HLA has said, especially when he's talking about social contract or he's talking about social justice. You must tell us why he said that, the background, why he's thinking this way, and is he answering someone? For example, is he answering Long Fuller or is he answering John Austin? Those are the things you need to tell us so that we know that you know exactly what HLA has said. Now, let me start with one question. It said, discuss the meaning and nature of law from any three philosophical viewpoints. The first thing that the student needs to do in this case is to tell us the meaning and nature of law first. After settling that, that's when you now go over to three philosophical viewpoints, like maybe natural law, feminist jurisprudence, critical legal theory, historical school, But you must first tell us about the meaning and nature of law before you go. And then in your own conclusion, which you may not put, you now tell us what you think about the nature of law. Please don't rehash what those philosophical views have said, except that you believe in it. If you believe in what they said, but you still push it forward better, for us to know that you understood what they have said and you're leaning on them. Now, another question says, even though law is not a legal concept, students of legal studies have always faced the task of attempting to define it. Though it is true that the definition of law has no serious legal significance. What then is law? What does the examiner want? The examiner first wants you to decipher whether law is a legal concept or not. Because he said, even though law is not a legal concept, students of legal studies have always faced the task of attempting to define it. Though it is true that the definition of law has no serious legal significance, what then is law? So you must first show us that you know what law is. Maybe law is a body of rules, full stop. Is it a legal concept or not? You try to explain to us. They have said it's not a legal concept. You agree. But you tell us how it is not a legal concept. Now, it says the definition of law has no serious legal significance. Yes, because whether you define law or not, law is always in operation. That's what they mean. So you will now tell us what legal significance is, because this is theory. You tell us what legal significance is. You now tell us what law is. how do you tell us what law is? You now go into what jurists have defined as law, because there will be many definitions of law. St. Augustine has his own definition of law. Thomas Aquinas has his own definition of law. John Austin has his own definition of law, and the rest of them, Jeremy Bentham. So you'll be telling us those definitions, because he said, what then is law? Obilade's definition of law, you put it. Any other definition that you know, then in conclusion, what you also think as law, you put it there. So with that, the examiner will know that, oh, this student understood the question. Because most times we don't understand the question.
Let me ask a question there. Now, how does a student draw the line in terms of answering a question like this? Because one of the questions that students have asked us during our survey is, how do you know when to stop when it comes to an essay question? For instance, this question talking about definition of law, there are vast amounts of definition. How do you determine where to draw the line for purposes of examination?
Because if the student wants to go the whole org, she doesn't have the time, or he doesn't have the time. By the time he's mentioning 3 or 4 different definitions of law, sociological school, historical school, realist school, it's okay. The examiner knows that this student understood the question. And then he gives his own definition. The student must always say his or her own view. That's when the examiner knows that you have not just read, cram, and pour down, that you have an understanding of what you're doing.
Thank you very much.
The other question says ambiguities and vagueness pose diverse problems in legislative drafting process. Discuss. How should a student attack this question? Let me use the word attack. The first thing the student will talk about is legislative drafting process, because the question is in reverse. He said ambiguities and vagueness pose diverse problems in legislative drafting process. With this, the question is in reverse. So the student will start from what is legislative drafting process and tell us the steps in legislative drafting process, drafting a bill. So what is ambiguity? What is vagueness? And give examples of ambiguities and vagueness. And all those examples are always supplied during lectures, like you want to draft a bill establishing University of Okokomaiko. And then in your items, there is always a long title, there is always a short title, but there's always a body of the work which is in sections. So, and then there is always a section on definition. So that definition should be done in such a way that there is no way for me to think this is what you are saying. No, that's ambiguity. The way the bill is drafted should be clear to everyone that this is what this bill is saying. The long title should not be different from the short title. Then when we talk about vagueness, we're saying that you are not passing any information. When we look at the bill, say a bill to establish a law faculty in Akoka. That's what you say. When we now go into the bill, we're seeing school of, you said law faculty, school of, no, so that's vague. So it doesn't make, so a student must know the nitty-gritty of legislative process. And here I must emphasize that English grammar is key, because ambiguities and vagueness settles on English grammar, because that is the medium of expression that we have. So if your grammar is not good, you need to enlist help, for it to be correct. So ambiguities and vagueness are things we'll always see, and for law students who may be following the law and the legislative readings, you find that there's some bills that they say they are dead on arrival. when those bills they come to the legislature for first reading, people say, what is she saying? But so those are things that makes for ambiguities and vagueness.
Thank you so much, Dr. Karibi-Whyte. So you have heard, students, that when you have your essay questions, you must first read that question very critically, dissect the question, do conceptual clarification, the key concepts in the question, state if you agree with what that statement that as said. When you state whether you agree with it or not, tell us the reasons why you agree or disagree with it. Give us various dimensions. Maybe there are views opposing it or conforming to it. Give us those parameters and make sure that as much as possible your answer is robust. And you have also learned that your English is very critical. I've said it before, you are students of law, you must have passed your English language and literature in English at secondary school level. These will play out now that you want to answer your essay questions. Thank you so much, Dr. Karibi-Whyte. We hope we can rely on you for further elucidation of the law. We'll see you at the next